Whatever. Where is intro? Noises. Yeah. Welcome to the Listen to This Bull Live podcast. My name is Matt Mulholland. This is Tony DiUlio.
That's good. That's impressive.
First try.
Yeah, I know.
I know. I'm so excited about it. DiUlio. Honestly, I feel like, are you married?
I am.
Did she spend just a lot of time just going DiUlio, DiUlio, DiUlio over and over?
I saw her practicing signatures. She was actually excited. She was a Thomas before, which was really boring for her. So
Thomas is boring.
She liked having DiUlio. It was nice.
This is one of those words that I would just say over and over again just because it sounds like fun to say. DiUlio. It's almost like the word smock.
You're right.
That was for you Calvin and Hobbes fans out there. The hat is back. Yeah, I brought it. My wife washed the hat. How about that? This is Tony. Tony is a badass attorney. I like badass attorneys because, well, they're badass. He works in most states on the East Coast except for Georgia, mostly because I don't think he wants to work in a state that I work in.
I try to avoid I try to avoid Georgia as much as I can.
I heard you.
Yeah, fair enough.
Yeah. Well, you guys, we are at the First Party Claims Conference, Fpcc. This is a conference for public adjusters and insurance adjusters, although insurance adjusters don't show up. So it's really mostly for public adjusters.
Yeah.
Attorneys.
Yeah, they've got some industry people, some engineers,
right?
Contractors, that kind of stuff. But large majority, it's public adjusters.
I mean, these are my people, basically, and
our people.
They're mine. So we've been enjoying the second day of the conference. I missed the whole first day because of Southwest Airlines. And I think a lot of people actually missed that day.
Yeah, the first day is always quiet. There's some introductory classes, but today's the first real day, in my opinion.
This is the big day. Yeah. So, can you guys hear us okay? Please let me know. Tony, do you work in Tennessee? Already people want to hire you instantly. All I did was call you a badass.
That's fair. That's good. So I've done 2 claims in Tennessee before. I'm not personally licensed there, but I've got local counsel who can pro-hoc me in and can assist with Tennessee claims.
Okay, well, there's
you go. There's very few states that I don't have at least someone that can get me in. Unfortunately, Georgia's just one of those places, but I'm happy if there's an attorney there willing to step up for me, I'm happy to do it.
Well, I mean, you could probably do some co-counseling with like Remington Huggins or something like that with Huggins Law, but I don't know if I want you in that state.
Yeah, well,
since you've avoided it for so long, I feel like you're out. You're out.
Well, look, the reality is in this industry, you really do need attorneys that know what they're doing in this field, right? It's not good enough to just have an attorney. You need an attorney that knows what they're talking about. And when it comes to first party claims, there's just not a lot of us.
Well, what's wrong with a personal injury attorney getting into this?
So
aren't attorneys attorneys, Tony?
Right? Wouldn't that be nice? No, I mean, that's like asking me to be your criminal defense attorney, right? I would be so useless in that area of law. Interpreting an insurance policy, understanding breach of contract, bad faith, unfair claims practices, it's a niche practice, just like any area of law. You don't want me to write your will. You just don't want me to do it. But you also don't want that personal injury attorney who knows everything about your tibia or whatever you broke in that car accident. You don't want them worrying about what your insurance contract actually allows.
Yeah. I don't want you to write my will because I don't want to think about my own death.
That's also fair.
It's one of those morbid things that I just don't want to do. If you are one of my audience members and you also don't want to think about your own death, let's do it together. I'm not thinking about it. I think we did it together. All right. So today I sat in one of Tony's classes and it prompted me to try to get him onto this podcast. We were talking about appraisal and some issues, new problems, and all the concerns that come with appraisal. And I wrote a ton of notes, but one of the things that stood out to me, and you guys, if you have questions on appraisal or really just about anything, this guy's very smart. He's like ridiculously smart, but mostly let's try to stick to appraisal for a little bit. If you have questions on appraisal, stick them in the comments. I didn't know this, but Georgia has some case law from the Georgia Supreme Court, Lamb v. Allstate, where the attorney for the policyholder didn't show up, and there was some bad case law that came out of it. amount of loss, which is what the contention is for appraisal. It's a dispute resolution that if you have a difference of the amount of loss, then either party can demand appraisal. In Georgia, amount of loss is deemed to be just a dollar amount for the agreed to scope.
Yep.
They didn't give any more language in that, just scope. They didn't define scope. I thought we were the only state.
No, so
Turns out we're not.
no, yeah. New Jersey had taken a similar stance. Unfortunately, before I got to fight it, one of the things I was explaining to Matt here is that, you know, carriers have a tendency to pick and choose what cases they're going to allow to fight through litigation, right? Because they've got the power. If they don't want to fight a case, they think that they're going to have a losing side, they pay the claim, case is over. If someone like me who knows what they're talking about is on the other side, they've got a much higher likelihood of settlement rather than trying to take that case all the way. So what happened in New Jersey, similar to what I hear about in Georgia, is an attorney took this case up through the appellate courts into the Supreme Court in New Jersey and made the same determination that in essence, scope was only, or appraisal was only a question of what do we agree upon in the scope? What's that dollar amount? That's all you get. Other states like the sister state in Pennsylvania, for example, says, no, it's the amount of loss. That question is not just about, hey, how much is this one piece cost? It's how much damage was caused by this covered loss and what does that cost to repair? One of the things we went over today was the New York standard policy and how that
Standard fire policy for a lot of people, if you know it that way.
Sure. And that standard fire policy has language that says the appraisal is about the actual cash value or the amount of loss, meaning we're not just looking at price, right? If we were only looking at price,
right,
actual cash value is what would have survived all of these different valuations, different changes in the policy. What they stuck with was amount of loss. So that as a result, what really is in dispute is what damage was caused by this agreed upon covered loss. That's what we're willing to appraise.
Do you think, this is your personal opinion, do you think that scope is the same thing as coverage is?
No, you have a covered loss, right? Coverage is about what happens. Scope is about the damage that is created as a result of that covered loss.
It'd be the scope of damages.
Correct. Scope of damages.
Scope could also be the scope of repairs.
Absolutely.
Which could be two separate things.
Sure.
Amount of loss, if it doesn't include scope, I feel like the courts should really specify, do they mean scope of damages or scope of repair? I think that they meant scope of damages, meaning that they didn't think that coverage was appraisable. Mm-hmm. So the scope of damages, the damages that were agreed to of being covered loss, that isn't appraisable. But what it takes to repair that, the amount of loss, and the scope of repairs involved in that is appraisable. And I think that when they use the word scope, they really meant scope of damages, but they didn't define it. Did they define it in Jersey?
They did not. So
bastards.
I know.
You judges in Jersey.
So
stop being like Georgia.
What happened is the argument that went forward was, look, you can't possibly go beyond our agreed upon scope because then you're making a coverage decision. And the courts bought the argument saying, well, it's not our job to determine if the roof is covered or not covered. It's our job to determine cost, and that's what appraisal is about. So we're going to limit it just to what everyone agrees is covered, right? But what they have come out to say, or what I think Matt is saying here, and we're all arguing is, well, no, we know that the roof is covered. We need to know how much damage, what the scope of that covered damage is. That's what's really appropriate for appraisal.
So coverage in a policy is listed very simply. Coverage A, dwelling. Coverage B, other structures. If they open up coverage, they've opened up all of coverage A, haven't they?
That's exactly right. Right. And as soon as they open up that coverage, now you've got a question of, okay, what is that damage? What's under that coverage? That should be appraisable everywhere.
But the plot thickens and actually ties into the question that we got from John Clues. When appraisal is over, is it over? Homeowner after realizes the shingles are not available and should have their entire roof replaced.
So this came up during the conference today. One of the questions that always comes up is, what if something changes after the appraisal is finished, right? What if there's new information? If it's something that hasn't been appraised, you can bring that back, right? And you don't have to bring it even to appraisal. You represent it to the carrier and say, look, this went to appraisal. This repair went to appraisal. We've attempted it. It's not possible. There's a lot of carriers out there who will want to look to say, try it first, right? If you have actual evidence that you've tried to repair and it's just not possible, that can be represented to the carrier.
So you're representing damages that are discovered after the fact.
Correct.
Right? New information that wasn't previously appraised.
Exactly.
New scope that wasn't previously appraised.
Sure. Right. Discovering damage inside of a wall, right? Stuff that you might not have realized. Oh, now I need to redo the insulation.
Sure.
Right. You didn't realize behind the wall, maybe it was blown in insulation. You put in for, R12 or whatever you're using in your state. And if that's the case, now you've got a new information that can reopen the claims process.
So if that scope is now appraisable because it wasn't previously in the appraisal award or even appraised, does that mean that scope really is separated from the amount of loss? Because the appraisal does set the amount of loss, right?
The amount of known loss. So you can't, now I admit I'm putting a word in there that does not exist within the policy or the case law. But the truth is you can only appraise what is known about. And it's why every state that I've practiced in, their Unfair Claims Practices Act has specific language that says if new damage is discovered, the carrier must consider that as part of the loss. So they can't just cut you off because you've gone to appraisal and have a set amount. If you get new information, it's something that must be considered. And again, I want to stress, this isn't even, in my opinion, something that should be presented in appraisal. It should be presented by the property owner or the adjuster after the fact to the carrier. This is outside of appraisal. They want to re-engage appraisal for those new things, so be it, but it's not automatic.
So what if the appraisers are the ones that uncover it in a state where the scope is set and the appraisal is set for only that scope so far? If they discover something new, should they bring it up to their client to see if they want to add that to the scope of the appraisal?
I think they have to. I think you've got an ethical obligation. If new damage related to this loss is discovered, you have to notify the parties. And at that point, it would be up to the parties to determine, is this going to be part of the appraisal or not? Because if you don't, right, let's just play this out, and you don't notify the insurance company and the client, the property owner, as to this new damage. Later down the line, that property owner finds out that there was additional damage that was discovered, no one told them about. Now you've got some liability concerns.
Well, no, they probably won't even pay the award or those portions of the award anyway. At least they wouldn't do that in Georgia because they're all bastards. Insurance companies are bastards.
If you don't know this, and I assume it's been said sometime on here, insurance companies are in the business of not paying insurance claims. The misinformation campaign that they have out there about being good friends and good neighbors is simply a tool that tries to make people believe that whatever they say is true. It's just not the case. People fight me often on this on public forum type areas, but the truth is insurance companies don't make money if they pay out everything that they're supposed to. So they are in the business of making sure everything is not paid out. You've got to recognize most claims don't have public adjusters on them. The large majority of insurance claims presented to carriers don't have adjusters. So the only thing that is maintaining the balance is that marketing campaign for these homeowners and property owners to think, oh, well, if they say I'm not covered, I believe them. That's what's been created here. I know. It's frustrating.
So then obviously, and to answer this question, then can they go back and reopen for those damages? In certain states, they actually have different types of, they'd almost call it a supplemental claim. You can always reopen a claim. In every state, you can reopen something that's been closed by the insurance company. That's bullshit language to make you think that it's done and you can't get any more.
All a closed file means. I'm sorry to interrupt.
No, go ahead.
So all a closed file
I'm going to interrupt you now.
Is because
it's only fair.
All it means is they are not going to be doing anything proactive on the file. That's it. That's all a closed file represents. And I've got testimony on this because I've asked carriers, why are you sending letters saying we're going to close your file? They say, well, that just means we're not going to do anything more on it. It doesn't mean you can't. You can always reopen that claim, and you absolutely should if you find that new damage.
Absolutely. So I think that's Conrad. Conrad, if that's you? Yep. All right, another question. Besides the term, where can you support this and documentation to be able to appraise new information? Is there any case law or something to support that?
So when it comes to new information, it's not about sending it to appraisal. I can't stress enough. If you find something new during appraisal, it's not something, in my opinion, that should be appraised until the parties send it there. It's not up to the appraisers to add it in, but I think they've got an ethical duty to do it. So they notify the adjusters for both sides, or the client and the carrier. That's up to them if they want to send it to appraisal or not. It is part of, again, statutory law. Well, again, in the Unfair Claims Practices Acts for the states, they have provisions regarding the ability to reopen claims based off of new damage, and it's based off of the contract language within the policies themselves.
Ultimately, the insurance carriers have to investigate any claimed damages. So
Yes.
if you have new damages that you discover, you have to make claim for those damages, and then that triggers the carrier having to investigate those claimed damages.
Correct.
Technically, because of the way that is worded, if you have a property and you want the insurance company to go in and investigate everything, they don't necessarily have to. They only really are required to investigate what you claim. So make it very clear what the damages are. I mean, you could probably argue once you get to a court of law that there's a certain amount of reasonability that they have to investigate a whole roof if the roof is in question. But that doesn't mean that they have to go into the basement to investigate anything if you're saying that there isn't anything down there. So claim everything. And if there's new information, claim it and put it in proof of loss or something, especially if you're a PA, so that you trigger their requirement to investigate.
Yep.
You agree?
100%. If there is no requirement, look, if you're claiming exterior siding and roofing damage, but you've mentioned nothing about the interior of the property, there's nothing that requires the carrier to come in and say, let me see if I can find some water damage inside your house, right? That's not their responsibility. But you should absolutely, especially if you're a public adjuster, be making that investigation and present all of it, right? Present any accidental direct physical loss that you can find to that property, and leave it up to the carrier to say, you're not covered for this, right? Their burden in every state that has an all-risk policy is going to be on them to prove the exclusion. So make sure that you present that damage and give yourself the opportunity to get it covered.
Yeah. Frank Dalton, closed file is nomenclature used by carrier. For all of you that don't know, nomenclature is a type of gnome. They're very, very short. They're roughly 7 inches tall. They dance around naked at night. I don't know. I ran out of things to say just then. It's bullshit, basically, is what Frank Dalton said. Maybe I should start changing my words.
Yeah, maybe a little bit.
That.
But nomenclature. The truth is, yes, it is just nomenclature. It's just a term of art, if you will, for the insurance companies to make you feel like there's nothing more you can do.
Yeah,
that's the goal.
Insurance companies use people's perceptions of words all the time.
Yes.
All right, you said direct physical loss earlier. Now, all of my audience knows that direct physical loss includes all the consequential damages that occur as a result of the proximate cause. But not everybody knows that.
Yep.
They use certain terms against you because it has changed its meaning over time. You and I were talking earlier about what people could do, or what the biggest issue is that public adjusters face. And I think the biggest issue is a lack of standardized terminology.
Sure. So, it's really interesting to bring that up, because one of the things that I'm working on right now is a project with a few different groups to try and create a standard policy, a baseline, a new, in essence,
HO3?
A new HO3 that can be the baseline, like the New York standard fire policy. And to say, these are the minimum standards, and here are definitions that you can actually understand as a consumer. I was talking in one of my fun facts that I give out in a lot of these talks is about the Flesch scale. And it's all about the readability.
Funny. I actually have the Flesch scale in my talk, bullshit insurance companies feed you.
Oh, really?
Oh, yeah.
All right. Well, check it out. It's worth looking at. But
we had a very similar talk.
Yeah.
You've used much more professional terms.
But the short version, to reiterate, is that, in this Flesch scale determines the readability of something. The examples that are given are it's a scale of 1 to 100. The higher the number, the more readable it is. So Dr. Seuss might be a 98 on the scale. The Bible was a 66.
I kind of doubt that.
Right. Sure. Depends on which Dr. Seuss. Right. Right. Fox and Socks is probably like a 3.
Right.
But
Right.
Yeah. But the idea is that the higher the number, the more readable it is. The examples they give: Bible is a 66. Einstein's theory of relativity is a 17. Insurance policies, a 10.
So the way that they actually calculate this, I've done a little bit of research on the Flesch scale. They determine how many syllables each word in a sentence have, how many words each sentence has, and they do some averages based on this kind of information. All of this is completely arbitrary. None of it has anything to do with whether or not that word has multiple meanings or not.
Sure, which only makes it more complex.
Oh, it's ridiculous. And then the insurance companies have the file and use policies for most departments of insurance. When they submit a file to determine if that policy can be sold in that state, the Department of Insurance or whatever organization that approves that, they have a certain amount of time to approve it. For most states, if they don't approve it within a certain amount of time or deny it, it's automatically used. It's automatically approved. For most states, the Department of Insurance or whatever organization regulates the policies, they don't give themselves the power to remove a bad policy, at least not property. They give themselves the power to remove bad health policies and bad auto policies, but not homeowners or business property policies. Correct. And I think that's ridiculous.
Oh, it's absurd.
Department of Insurance, if you are an insurance commissioner, don't you want more power? Come on, just change the regulations, add a few words in there.
Truthfully, I don't even know if it's about power, right? They have the ability. The problem is they don't have the staffing to review all of them. The number of filings that are done for these insurance companies, you've got to remember, they're not just looking at property, right? They're looking at the liability side. They're looking at auto. They're looking at healthcare. They're looking at life. There are so many areas of insurance that they have to review. Okay. They're getting hundreds of changes a month. And to actually review them, it's just impossible with the staffing that they have. It's a shame. It should absolutely be reviewed, but so much slips through the cracks.
I just want there to be the ability for a Department of Insurance to say, hey, this language was determined much later on down the road after there was a shit ton of complaints that were filed to be misleading or to provide the carrier with the ability to misrepresent that language.
So I'll give you,
which is bad and not allowed by most states.
Yep, and that's exactly right. But look, the reality is the only avenue we have to defense is the public adjusters first and the attorneys second. And we have we have a responsibility to be the enforcers of what we know is supposed to be the right policy language.
Right.
I push back. There's a great example. It was a State Farm case where we got a jury or a bench award for bad faith because they had added a provision in an endorsement. And the endorsement language, you'll love this, started off, and the very first line is, we're not intending to change your coverage. It was the first thing the State Farm says.
It's an endorsement.
And then the second thing they say is, however, depending on how this is interpreted, we may be reducing or eliminating coverage.
We might
be doing that. We're not telling you
how it's interpreted.
Yep. So we're not intending to change it.
You're kidding me.
But depending on how it's interpreted, we might be reducing or eliminating. And here's the real kicker. Then underneath the actual endorsement is additional coverage. So they tell the property owner, we're adding this new additional coverage into your policy. So they have at the same time said, we're not changing anything. We're eliminating things and we're giving you new coverage. All on one page of an endorsement.
But it might be misinterpreted, or depending on the interpretation.
Yep.
It's like they wanted you to interpret it differently on purpose.
Yep. And what happened?
So strange.
And what the court came back after hearing the testimony, where State Farm admitted on the record that they did reduce coverage. By the way, once they do that, they admit they reduced coverage, but told the clients that they weren't intending to change your coverage. Court said, look, at a bare minimum, there's a misrepresentation understanding. Here's your bad faith money.
Those policies would not be valid at all. No. The renewal would not have gone in. At least that endorsement wouldn't be valid. It would never be applied.
And you know what they did in response? They changed the actual policy. They took out the endorsement, put it into the main policy.
Changed everybody's policy.
Changed everyone's policy.
Oh my God.
To get around my rule.
What insurance company was that?
State Farm.
See, this is why I like this guy. He named him.
Oh, absolutely.
Say it again.
Oh, there's no State Farm.
Oh, yeah. Do it again.
State Farm.
Oh, yeah.
State Farm.
All right. Can you advise me on a bad faith claim dealing with mold that's starting to cause health issues? Not during a podcast,
right.
Conrad.
You can.
Jeez.
If you need my information, WDB Legal. WD as in dog, B as in boy, legal.com. You can get all of my information right there. I'll be happy to talk to you.
There you go.
Perfect.
All right.
Check the link.
Quite some years ago, a tornado took down a tree. Several damaged the house. Homeowner has found more damage. Can it be reopened? It depends on the state because of the suit limitation period. So quite some years ago.
So this is actually a really interesting thing that I've been fighting a lot. The suit limitation has nothing to do
with the coverage.
No,
just on whether or not you have to sue.
That's it. It has nothing to do with their responsibility to adjust the loss or appraise a claim. Those two aspects, they cannot get out of adjusting or paying a loss or going to appraisal. No,
they can get out of all of it. because they can't have their hands slapped anymore because you can't sue.
And
So they can just say no.
Would
Whether
be-
or not the policy is really written that way or not is a whole other story.
So interestingly enough, they've tried to do that with me, and we have pushed back in 3 states now and been successful, and we're on appeal in a 4th state to try and get it overturned. And what the courts have come back and said is, hold on, carrier, you have responsibilities. This is a contract, and you have responsibilities under that contract to do certain things. You can't just come back and say, I'm not going to comply with my responsibilities because you can't sue me. And the courts have been very frustrated by carriers trying to do that.
So
Now, there's still issues with prompt notice. There's still issues with the ability to investigate. If we're talking years down the road, there are problems. But simply saying, I refuse to do it because the suit's over.
So in these cases, then the Department of Insurance is performing an investigation and then fining the carrier, I would assume, because that's what can still happen. The policyholder still isn't, they're not suddenly given the right to sue, are they?
They are, because now you're getting, so this is the amazing part, right? So this all started, the reason my fight started, we had a claim where it was being adjusted for 3 years in North Carolina. And the carrier came down on 3 years and a day, said, we're denying the remainder of your claim because you're past the suit limitation.
Right.
That was their basis for denial, which is not a basis for denial under the policy.
Farmers Insurance has written this exact letter to me, by the way.
You cannot deny a claim because you can't sue. It's not basis under the policy. So there's no exclusion saying you're not covered because you can't sue me.
Okay.
And the courts have come back and agreed with me and said, hold on, you can't do this. You can't just try to shirk all your responsibilities now.
How did you get the courts? Was it a summary judgment kind of a deal? Okay.
Yep. So, well, it wasn't. So it was a motion to dismiss. So the very first stage of the case is either preliminary
They were
objections
trying to dismiss based on
or
the suit
motion to
limitation.
dismiss. Right, saying you've got no right to file this suit. And the court came back in the motion to dismiss phase and said, nope, you can sue on this because you've taken this provision to a new level that was never intended under the policy.
How are they applying the suit limitation period to when the new damage was discovered at that point then?
No, they aren't applying the suit limitation
At
period
all. They're just like they're wiping it out because
Correct.
the carrier misused that portion of the policy,
Correct.
so they removed it from the policy.
Not removed it from the policy, but
In essence?
But in essence, yes, saying, hold on, you can't do this because otherwise the carrier, that delay tactic that the carrier tries so hard to use, it would be such a large tool for them that the courts came back and said, no, we're not okay with that. This is the difference between using an attorney that knows what they're talking about and the attorneys that have no clue about insurance claims.
God, dude. Yes.
Happy
That was
to
a
do
bad
it.
high five.
Yeah,
I'm
that's-
nerdy.
yeah.
All right.
There we go.
Second trap. Wow.
Yeah.
I have wanted to take that fight to a carrier so many times,
We can do
but
it.
I'm in Georgia.
Where I hear the judges aren't always.
Not so much.
Yeah.
God, that's amazing.
Yeah. And if it's the right
Is it-
case, if we've got the right situation, you and I can talk
Is
about
it
fighting.
is what courts did that come out of? Is it case law? or is it-
Pennsylvania. Well, see, the problem is it was never binding. It's all state court level. So there's no appellate decision on it.
I
So
mean,
it's
it's
not
persuasive,
but it's
though.
absolutely persuasive.
That's something.
Yep.
That's something.
Right. We've
Wow.
got some precedent on this now. We now
Yeah.
know what some courts will do with it. So it's happened, like I said, Pennsylvania, New Jersey, and Virginia.
Hey,
North
guys.
Carolina, we're on appeal.
If you're an attorney watching this, and I realize most of my audience watches the show after the fact, but if you're an attorney and you're watching this, this is Tony DiUlio, which sounds so awesome. He's better than you. And that's all I wanted to say.
I know the industry. I spend a lot of time nerding out about this.
I wish Remington was on this show. He would be so excited to hear some of this.
Yeah.
Man, he's on vacation, by the way, guys.
Next time, have me back.
David Most, quite some years ago, we already talked about that. Yes, you can reopen it. All right, Anthony Hines, if you had to choose a few of the most important pieces of data to collect to help support major changes in the industry, what would they be? I'm going to stop there reading because that's a good question.
It's a great question. So what you're generally looking for is a pattern of practice. Most unfair claims practice acts require a pattern of practice to show repeated things, right? It's not
Systemic
once-off,
issues.
right? One-offs aren't good enough to really commit to change from these courts and from the insurance commission. So what we started doing for my office in particular, and you could do this as well, is start building your files of these are repeat issues that keep coming up and keep having to be fought and keep being won over and over and over again. So we'll have, issues with State Farm and their access provision where we keep winning and we keep fighting and we're successful, or State Farm and their ridiculous period of time language.
I don't think we've ever said State Farm so many times in one episode.
Oh yeah. If you don't know who I dislike the most, you probably figured it out. The reality is in this industry, it's become a big problem with carriers.
Oh my God.
Trying to do everything they can to delay this process, underpay claims. And look, there's no secret. State Farm is one of the big problems.
It's not a secret. Why do we keep trying to make it a secret? Like we can't say this.
No,
It's
so
factual.
So long story, when it comes to collecting data, you want that repeat information. You want the same offenders. Just create a database. It's not that difficult. Create some keywords for searchable purposes. Put it in a folder and save it for later.
Keywords. Somebody, Anthony, ought to build that into a CRM of some kind.
That would be good.
Anthony. He's doing some stuff. I got cut off on that. Maybe call him. Dude. Yeah, I'll do that. That was me. I wrote that. Frank, Tony. I'm not sure who you are, but look forward to meeting you. I like the cut of your jig. Frank Dalton is one of my partners in the National Claims Institute.
Oh, nice.
Yeah, and he's got one of the larger firms in Florida. Have you ever heard of Coastal Claims?
I have.
See, Frank, you're famous.
Frank, yeah, your
people just don't know who you are.
Yeah, people know you.
Yeah, but everybody should know who Tony is.
Yeah,
because damn.
Yeah, and we're just opening an office in Florida as well. The reality is,
right?
Every state, I would love to be everywhere. I would, but I've got to make sure I'm prioritizing places that have the biggest problems, and Florida is one of the top on that list.
So Georgia has a lot of problems. You're not there at all.
Yeah, and it's
Tony.
All right.
God,
I hear the message.
I hope you do.
I hear it.
I mean, you could always co-counsel with Roman.
Yep.
Yeah. All right. Anyway, right. Law of the land helps at least. Stop. Our firm Coastal Claims tracks carrier trends. It really helps. Actually, this is something that we did at All Good Adjustments too. We were doing like 3,000 claims a year. I know Coastal Claims does probably at least that number, but when you have a ton of claims and you're good at documenting shit, the amount of information you have, it's so easy to see market trends. It's so easy to see patterns in the bullshit that they do. And it really helped us tremendously.
Oh yeah. And one of the great things is, remember, these policies are written by a company, not by a specific adjuster. So if you have a carrier and an adjuster who continually pays for, let's say, 3 coats of paint versus 1 in a fight, right? They prime and do 2 coats.
Yeah.
You can use that information in future claims and say, look, the carrier paid for it here, 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 and here. Why aren't you paying for that? And you can use that information, because if they come back and change that, now you've got your ammunition to say there's no reasonable basis. You owe me for bad faith damages.
So that's good for an attorney, obviously. An attorney would be able to say there's no reasonable basis on all this fun stuff. Sure,
yes.
Sure. I mean, as a PA looking at this kind of information, they always say, well, we judge every claim based on its own merits and all that other bullshit that they say.
Sure.
Because that's the word tracks that they've been taught. But ultimately, you're right. I mean, I think a PA should present that kind of information anyway. How come you treated this other client of mine differently than this client? Do you dislike this client more? Is it the color of their skin? I'm not opposed to playing the race card.
No,
as a white guy.
It could be, look, it could be a lot of things. It could be race. It could be economic status, right?
There's got to be a reason, right?
How many claims have you gone into, anyone listening to this, where you have almost a hoarder-esque house, right? It's trashed. It's not in great condition. But the truth of the matter is that house is insured the exact same way as the pristine neighbor next door, right? There might be different depreciation, but that replacement cost is going to be the exact same.
It should be.
Absolutely.
It should be.
And if you have that data, you have an absolute leg up to present to them. One of my favorite lawsuits I ever had was a hailstorm that came by. Hailstorms affect all the homes in the neighborhood, pretty standard. Erie, who is particularly difficult up here on hail claims, covers 2 homes. House across the street has a different adjuster. That adjuster said there was never a hailstorm.
Because he lives 5 miles away and he never got hail at his house?
I mean, it's absolutely nuts, right? The same carrier has 2 different adjusters. One who pays the loss admits there's hail. The other one says there was not even a storm, let alone damage. It was a bad faith award, by the way. For obvious reasons.
For obvious reasons. There's a lot of bad faith in this industry. All right. Opie Waddell. Wow, Tony Robbins. You know who Tony Robbins is?
Tony Robbins, like the motivational speaker.
Yeah.
Yeah.
I think Opie is calling you Tony Robbins.
Oh, all right. Well, I'm motivating. I'll accept that any day of the week.
I'm motivated.
I hope so.
I'm very motivated right now.
Look, there's a lot of good fight to be had.
All of
here.
my motivation, though, is from the waist up. Just to be clear, all of it. I don't even know what that meant.
Yeah, that's fair.
All right. Barton Opik. I think he's out of Minnesota or Minneapolis. Minneapolis. Where is St. Paul? Minnesota.
Minnesota.
Yeah, I was so close. He might be out of Minneapolis. And I was thinking that was two different places. Those are the same place. Every time you hear State Farm drink,
Oh, please, State Farm.
I would
yeah.
if I had more.
will.
I'm almost out, and you don't have any.
That.
But you're about to drive home tonight. Chad Rums. Thanks, guys, for putting a lot of comments in. I really appreciate it. We like getting a lot of comments during the show, especially if they're questions, because it drives the conversation. So if you have any questions, please put it in the comments. We will get to it. We're having a lot of fun answering those for you.
Yeah,
so.
I mean, one of the bad look. Hopefully people recognize the resource that you can be and whoever you have on can be, because this is an opportunity to get answers to direct questions from people who do this a ton. Yep. And if you need that advice, we're happy to provide it.
Yeah, we're here for you. By the way, look how awesome we look. I got a new camera, guys. Look how pretty we are.
Yeah. I told Matt it makes him look good, which is really an impressive task.
It's so hard. Spell all my corp reps depots to compare as well. Corp rep depots? Corporate
yeah. So the carriers have corporate representatives that in essence act as a representative for the company that have to identify. As an attorney, you can depose them on any specific topic. So if I want to know intent, I say I want your corporate rep who can tell me everything about the intent of this language, and they have to provide that.
Really? Intent of the language in the policy.
Yep. So So one of the keys to this, again, knowing the right attorneys and knowing the right law, the intent of the policy is actually important. Carriers will always argue intent has nothing to do with what the language is, but it's not true when you've got any
How
ambiguous.
could it not?
Yeah, I know it's nonsense. But anytime there's any ambiguity within the language, or if there is even a difference between the reasonable expectations of the insured and what the policy says, intent comes in as a factor, and the courts will allow you to depose somebody on it.
Have you ever been able to, maybe you haven't asked for it, but maybe you could depose whoever the original author of the policy is?
Yes. So I've asked for that.
You've asked for it?
I've asked for it.
Okay.
The problem is the answer is always there's a lot of hands in the pot. Right, it's never.
Well, of course,
one
it's never
person.
just one person.
Right, it's never one person. So,
but they could send out a representative of that group of individuals.
Correct. Right. So they have to. Unless there's some court ruling that says otherwise, they're going to have to provide you that what's known as a 30B6 representative,
right, for
whatever issue you want. So if you want to know, I want to know who wrote this and why they wrote it, you can get it.
There's some information out there from the ISO group that made the ISO forms, the HO3, and they actually have a lot of language in writing with the original draft of the HO3 that gives the explanation of what their intent was for each of the sections, which is really kind of interesting. It's, of course, all of these carriers, they've completely gone off the reservation from the HO3. They've gone in every different direction. So they could always say they don't have the same intent.
Yeah, everyone, I mean, you'll see constantly now it's ISO language in the policy, but it's not the actual ISO form. And what they have done is tried to manipulate it to whatever they specifically want. But it's one of the ways that these COVID losses, I know this all started with appraisal, but the COVID loss of business income claims, one of the ways we've been successful on those fights is because ISO released language saying that your policies actually could be open to virus losses, and you should do something about that. So that's how we've won these cases without the virus exclusion, is to show that ISO actually puts out a bulletin that says, you're open for liability here, do something about it.
You guys just heard that he said he was successful, right? You guys heard that? He can't tell you everything there. But he's successful.
I'm successful.
It's pretty fucking awesome is what it is. I wish I could tell stuff. Not that he told me anything. He didn't tell me anything, lawyers. That's my disclaimer.
Stupid rules, stupid confidentialities. Ugh. Frustrating.
All right. Yeah. Fuck you. Yeah. Everyone, subscribe to Matt's TikTok. He needs 1,000 subs to go live. Hey, guess what? I do have a TikTok. It's under Listen to This Bull, but my name is spelled with only one T-O-P. Come on, man. Killing me. Great discussion tonight. Super valuable. Thank you, guys. Anthony Hines. Frank, when I worked for a carrier, that if I said their name, you would have to drink. Well done. Long Island, they used weathered, damaged, or aged wood as an exclusion during Sandy. Aged wood.
Yeah. So what happened? Actually, I know a little bit about this. We did hundreds of Sandy claims. Carriers were coming in that had, if there was old weathered wood used for the property, they were claiming that was evidence of long-term leakage and seepage, and as a result would deny losses.
Was it used on the property on purpose because it was old and weathered, like barn wood? You can buy that right now separately?
Sometimes, yes. It wasn't as often as where you would have an old bathroom leak that was still, I mean, you could still build over it. It wasn't a problem, but you had old water damage there. Happens all the time. People just put over it, save the rafters, and the rafters have old damage.
Sure.
Now the carrier comes in and finds water damage in those areas that had old water damage and says, oh, sorry, it's not covered because it's evidence of long-term damage. It is, by the way, impossible to date rot. So if you have a claim for rot and the carrier comes in and says it's related to this loss, have them give you evidence as to how they know it's from this loss and not a prior loss 30 years ago.
Would they, regardless, still owe for the amount of damages that occurred during that first 14 days?
Absolutely. And I've actually got testimony from that, from Allstate. We had taken trial testimony from one of their adjusters who admitted the first 13 days of the loss are covered.
So they don't include the 14th day at all?
Nope.
It's completely out?
14th day is out, but your job as the adjuster should be, I'm only presenting the first 13 days of damage. I don't want a penny after that. Don't care about it. Not part of this loss. And then the great part is it's the carrier's burden to prove that the damage occurred on the 14th day or more.
Unless you're in Georgia.
They don't have a shift?
No. Well, I mean, the burden shifts. The burden of proof shifts, but there's just nobody slapping their hand if they do anything wrong. That's my point. If only there was a Tony in Georgia.
All right.
But, there isn't one. So if you live in Georgia, I'm sorry, Tony doesn't care about you.
Oh, my goodness.
Wesley Barber, this is a PA in North Carolina. I need to get Tony together with an attorney or two in North Carolina who geek out on this stuff as well. Tony even looks smart.
I think the first time I've ever been told I look smart, but
I wasn't thinking that at all.
So I have a presence in North Carolina. I've got a few open claims there currently. Yeah. I like North Carolina losses. We've been pretty successful there. So I'm happy to talk to your attorneys down there. That would be a fun conversation.
North Carolina is not too bad. It's not the best state.
No.
But and they don't have any of the bad case law. They've got a lot of, they're pushing really hard to try to get it.
Yep.
But that's not going to happen to an attorney like you anyway. So, Tony talked to me about something I didn't really realize until today. He said something that was fairly profound to me.
Oh, geez.
I know. And it wasn't even about that.
Right.
I'll leave that to your imagination. Insurance companies, when they're looking at, let me take it back. Attorneys on the policyholder side are looking to get good case law as well. And in order to do that, they need the right case. So they're always looking for the right case for things.
Right.
Attorneys on the opposite side also want case law. They want case law that helps them deny claims. And they're also looking for the right case. And the right case for them is one with a shitty attorney.
Yep.
So if you end up with a good attorney, how often are they going to go to trial?
Rarely. I mean, it doesn't happen.
So if you've got an attorney that you're working with that's in trial all the time and they're bragging about it, chances are good they're shit.
Yep.
Is that true for every state?
I would venture to guess, yes. Again, I haven't practiced in every state, so it's hard for me to blanketly say that's the case. But the reality is they're going to be paying the claims to those attorneys that know what they're doing. Because we're just more successful in court, and they don't want to take that risk. They don't want to roll the dice on a bad faith claim. State Farm has taken in the past 7 years 2 cases to trial with me, and they lost both of them.
But were they really fun?
Oh, it was a blast.
Man,
It's a blast.
it's
my favorite
I wish
part.
I
It's
was
my
an attorney
favorite part.
sometimes just to do that shit.
My favorite
Actually, you know
part.
what I really want to do more than anything else? I wanted to pose the shit out of people.
Oh, depositions are great.
Aren't they?
They are great.
I want to sit down with an attorney and just help them write the questions
Yep.
and then watch the video later from those
Yep.
questions.
It's
That would make my day.
It's fantastic.
I want-
I'll let you do that with me.
Yeah?
I'm happy to do that.
We're doing
I'll give you your fantasy.
Yeah?
Yeah, absolutely. I've got no problem with that.
He's not single.
You know, it's so interesting though. You find it's like those cases. So we have there's a seminal case up in PA, USAA or Green versus USAA. It's
Right.
a matching case, and carriers would never want to go to trial on a matching case because if you've got 3 sides of your home that have siding damage, of course you're going to get the 4th side, right? You have 4 out of 5 slopes that have damage.
Sure.
Of course you're going to get your whole roof. This attorney who will remain nameless took a case to the appellate court. 3 shingles damaged on a 24 slope roof.
He took that to appellate court.
Took that as the matching case to say, of course I'm owed
Was
for the
it-
entire roof.
Was it an incompatible roof to anything that's currently made? Was it like a 3-tab?
Truthfully, no.
Okay.
Yes, it wasn't at the time. It was a 3-tab. This was years ago. It was a 3-tab roof, and that's what they took. And the problem, I don't even care. I don't care if this was 3-tab versus a not made anymore. Asbestos.
There's
Asbestos.
still
The
that
problem
might have
is-
been something to talk about.
But 3 shingles on that size of a roof is never the case you want to fight. You don't want to be the person making law asking for an entire new roof when you've got 3 damaged shingles. That's not the right case. And as a result, we're now all in this horrible matching issue in Pennsylvania as a result.
I think matching is kind of overrated. The way that they're using the exclusions for matching is just stupid. Honestly, it really comes down to compatibility of the materials that are damaged and
Sure.
the rest of the roof. Because
Sure.
regardless of whether or not there's a matching exclusion, if they can't make proper repairs,
Doesn't
then
matter.
they have to pay for the whole thing.
And that's always the argument. I mean, it's
Yeah.
why it's so important that you understand the shift from English to metric in sizing of shingles. There's so many arguments to be made that you don't have to worry about matching as the argument.
Where to set that? All right. Let's talk appraisals on denied items.
So this is why the courts have come down and ultimately said that scope isn't appraisable, because what the carriers have done is said, well, hold on, if you're allowing scope to be appraised, then what stops a person from coming in and saying, well, all of the scope is in dispute. You've said it's denied. I say it's covered. That should go to appraisal.
All of the scope, meaning all of the property?
All
Now
of the
scope
loss.
means
no. So in a full denial, you're
Okay.
saying there's nothing covered.
So they're saying that coverage and scope are the same thing.
Correct.
So
And that's
pick one, insurance company.
right.
What do you,
But that's how they present
That's
it to the
so
courts.
stupid.
That's how they present it to the courts, and that's how they're successful, right? Because they don't have the people explaining to the judges. Look, I don't blame the judges all the time. Sometimes I do, but not all the time, because a lot of times it's about the attorneys who have an opportunity to teach these judges about law that they don't know. Judges can't know every industry that they have to rule on, right? It would be impossible. They have to be educated by the attorneys. And if you don't have the right attorney doing that, and all of a sudden you have a judge who's listening to this idea of, oh, well, scope is coverage, right? If I'm not agreeing to a scope, then I'm not agreeing to it being covered. That's the same thing, right? On its face, I understand just why
if
a
that
judge
is
might
the
think
argument,
that.
though, then that
But
at
it's not
least
right.
lends to scope and being scope damages specifically and not scope of repair.
Correct.
Is that the argument that was made in New Jersey?
Yes.
But they still said on the order, it said that scope, without any qualifications on what kind of scope they're talking about, scope was not included in the amount of loss,
Yes. They did not define scope.
just like Georgia.
Correct. They just said scope is not part of the appraisal.
Was it at
process.
least
so?
a split decision?
I truly don't remember. I don't
at
remember
least
what
Georgia had
I'll have to look it up. But so the short answer is, if there is something that has been officially denied in a lawsuit, and this is how carriers are getting around the scope issues, is they'll come in and say, you've got partial coverage, we're denying the rest. You've got coverage for these 5 shingles, the rest of your roof is denied. Now they're making an argument to say, well, look, scope's not even an issue anymore because we've denied it, and thus it's not appropriate. That's what they do
Can
in
they even
states.
do that, though? I mean, the policy doesn't really afford them the right to put coverage on that component level. Very few of them, anyway. There are a few that do, but for the most part, they pay for the repair replacement of that part of the property that's damaged or the damaged property itself. there's like 3 policies that I'm aware of that really specify component levels for coverage. So if it isn't broken down by component level, can they even specify a limitation to coverage A?
I'd argue no.
I don't think they can.
Yeah. I'm with you.
All right.
But the problem is making sure that the courts understand that.
Well, if only there was somebody. Florida policies have been amended to try to prevent first 13 days. Are you aware of that?
I'm not actually. So I don't know what policies in Florida have started to do that, where they've made that argument, but I can't fathom a way to do that. I don't know how you could say that you're not covered for leaks that occur over 14 days or more and also include the first 14 days, because then you're excluding all water losses.
I'm putting my email address in, which is Matt, spelled with only 1 T, at listentothisbull.com. Can you send me a copy of one of those policies, please, Chad? And I'll forward it to Tony.
Yeah,
I'm going to put his information in the comments on the video when it reposts anyway. Dimitri, I cannot pronounce that last name. That is not happening.
Goodness.
Do you take claims in Illinois? Do you?
Actually, one of my attorneys in my Philly office is licensed in Illinois. He's from Chicago originally.
So would you do any kind of claim out there, or really just large loss because it's only one attorney?
Yeah, it's going to be larger loss type stuff. It's hard to take a $20,000 claim in Illinois, but if it's large loss or there's good claims for bad faith and unfair claims practices.
Fret not, my friends. I had this conversation earlier, and this is something I'm working on, and it's coming. But one of the things that the National Claims Institute is attempting to do is to develop a course that will teach a public adjuster how to present a claim to their attorney in such a way that it's easy for the attorney to pick it up and run with that ball without having to dig through all this crap. All the stuff is organized, bullet pointed for them, so that they can take on smaller claims and feel good about it, because it's not going to take as many man hours. Would you take smaller claims if that was the case?
Oh, yes. So
hell yeah, you would.
You know how your fantasy is to write questions for a deposition?
Yeah.
You're now talking about my wet dream, because that sounds amazing.
Doesn't it?
Right?
Doesn't it?
You know what the number one thing that shocks me?
I gave Tony a wet dream.
Right? Number one thing that shocks me about claims that I don't see from a large majority of adjusters is a rebuttal letter to a denial. If you are trying to contest a claim, you want to go to suit on it, there better be a rebuttal letter.
What, they get a denial, they just hand it off to you immediately?
Correct.
They don't even try to rebut it? How are they even doing their job?
They're not.
Oh my God, is that mostly in Florida?
No, it's everywhere.
Are you serious?
Yes, it's everywhere.
Come on, PAs. Come on.
It's
jeez. Oh, and whoever you are that dropped all the silverware too. That I think she thought I was yelling at her. Tony, is there anything with a public adjusting firm assisting another public adjusting firm when volume is high and they need assistance? Anything wrong with that, you think?
Is it okay? So. Oh, there's nothing wrong with it. No, absolutely not. Adjusters. I know adjusters all the time.
Maybe though, in certain states where there isn't a entity license. So Georgia, for example, does not have an entity license. You have a public adjuster license, and the PA has to be named on the contract with their email address and license number and all that, right? And they have to testify as they sign off on this thing that their license is current and they have a bond and whatever. So in the state of Georgia, everybody that might touch that file as a PA would have to be on that contract.
Yes. So you always want to be careful when it comes to the contractual side of things, right? Making sure that your licenses are up to date, you're working under the right entities. You want to be very careful. And that usually involves a phone call to an attorney that has specialized knowledge of the regulations for licensure and all of those things.
Sure.
But conceptually, when it comes to claims, there's absolutely no issue with it whatsoever.
Now, obviously, you're a public adjuster. As long as you're licensed in the state that claim is in, then you should technically be able to help out another public adjuster on that claim. But you might have to add yourself to that contract, which might need a new signature at that point if you're in a state that doesn't have an entity license.
Correct.
At least that's how I understand it. Yep. But I'm not a contractual lawyer. I don't think you are either. So
no, if you want to talk to someone, if I could recommend, am I allowed to plug somebody? Holly Soffer.
I was going to say Holly.
Holly does.
She's got a lot of all that compliance stuff already set up and everything.
She's always people call me all the time about their contracts. I tell them, look, I'm a pro when it comes to insurance contracts, but when your PA contract comes involved, it's just not my area.
Yeah.
Call Holly. She's absolutely fantastic. It's worth speaking to her. Look her up online. Holly Soffer, Kellis and Soffer is her firm. She's worth talking to.
No, she's fantastic. I might put her on the show soon, so if you guys can hang out a little bit. I'll put her on the show at some point. I worked with Holly with Appia. She was representing Appia at the time when I was representing Gapia against Georgia House Bill 254 recently, and we were working together to get some of the languages changed. Very smart woman. She knows what she's doing.
You guys did a good job there too. You were successful in pushing back, and
we got a lot of it taken care of.
Yeah,
I feel like
good.
there was a few things that, for the most part, it's a decent bill as a result. It was definitely going to be tough. I don't know what that means.
What was that?
1.37 and 15,000 in the example. What example? I don't know. I don't know what that is.
Sorry, missed that one, guys.
Does a cat loss allow different public adjuster rules / laws compared to a single loss?
So the only thing I think could be applying to is if there's different regulations for when there's a cat situation. So hurricanes, large loss, named storms. There are some states that have regulations when it comes to fees. For example, when there's a cat loss. So
yeah,
hurricane comes through.
There could be some licensing differences too. If you have adjusters coming from out of state that don't have a state license, they might be given.
Oh, maybe that's what they're talking about.
Maybe.
Right? So coming up. So if you're talking about, like, let's say you're an adjuster in Florida coming up to New Jersey for a hurricane, you're not going to be able to practice without that license. There can be expedited licensure that can happen during storms. Certain scenarios that allow you, but you still need to get licensed. You're not going to be in a scenario where you can just come in willy-nilly and start assisting on those claims.
In Tennessee, after the big tornadoes went through Nashville a year ago or 2 years ago, you could act as a public adjuster in Tennessee for 6 months without getting a license.
Really?
As long as you had a PA license from a different state.
Interesting.
Yeah.
All right. Wow. So that's good to know. I had no idea states would allow.
It's the first time I've ever heard of it applying to public adjusters specifically. It's kind of cool.
So
it was bold.
I learned something new.
Now you know.
I love that.
I love it too.
Yeah, that's great.
When will Chip Merlin be on the live show? Apparently, Opie doesn't like you that much and thinks that Chip Merlin should be on the show and not you.
Oh man,
thanks, Opie.
Yeah, geez, Opie.
Way to make my guests feel good.
I love Chip. I had a conversation with him today. We always talk at these meetings. Chip and I are on the same side with this. There's no real secrets here. He's done a great thing for this industry. The amount that he's been able to fund and assist in this area is fantastic.
Definitely.
And he would be a worthwhile person to have on the cast. There's no question. But
I heard that your firm was willing to fund a lot of stuff, though, especially things involving Listen to This Bull and National Claims Institute.
Absolutely. I've told you before I will do that, and we do have to set that up. But we also fund. Look, the reality.
You never told me that before.
Right now, and now I'm on record too. So
it's on record.
But truthfully, my firm and others, I've done a lot to try and give back to this industry, because the truth is we are against a monolith when it comes to money and power. The carriers have it all, and we've got to do what we can. So
I feel like we're everybody is so individualized in this industry on this side, on the policyholder side, but we're all Davids against Goliath. That seems to be this monstrous thing that definitely has plenty of players working together.
It's why
we need to collaborate. We need to become a tribe of Davids.
It's why everyone should be joining some version of an organization for adjusters.
Right.
Ideally, your local ones. I truly look. NAPIA and Appia are fantastic. You should join them.
Your local
unbelievably amount of good for this industry.
Yeah.
But if you really want to understand your industry, really want to get involved and help, something that can cost $300 for a whole year, tax deductible, by the way, can allow.
Depends on the Appia.
But can allow, like my organization, MAPIA, Mid-Atlantic Public Insurance Adjusters Association, we have a lobbyist that can now push back in New Jersey and Pennsylvania just with a couple, we've got 50 members, $300 funds that because of, additional donations from my firm and others. That can make such a big difference for the industry.
Absolutely.
It's worth it.
At Gapia, we have a lobbyist as well. Yeah. And the membership fees by themselves are definitely not enough to make up that difference as a lobbyist, but it takes care of such a large portion of it. It's tremendous. But the amount of good that you can do, or at least the amount of bad that you could prevent, if anything else, as a result of having all that, it's worthwhile. You are in business you should protect the business that you're in. And this is the best way to go about doing that, I think. So join
can't-
your local APIAs. But there are other organizations as well that aren't local, like the United Policyholders, the American
Sure.
Policyholder Association.
The Amy Box group has been fantastic
Oh,
in
yeah.
helping.
Yeah.
They've really done a great
I
job.
think
And
that I'm
they're-
going to be joining that organization.
They're part of some
Talk
really
me
great
into
concepts moving forward and what we're going to do to push back as a whole. The reality is, not one of us, Chip Merlin or otherwise, can push back by ourselves. We have to do this as a group. There's enough business for all of us, right? We can play nice and we can do the right things together and actually make a difference.
Can we start referring to the
Oh, they want us to call State Farm the carrier whose name we don't
whose
speak.
name we cannot speak. The
Like in Harry
carrier
Potter.
who shall not be named.
Right.
Yeah.
He
Because
who shall not
then
be
Frank
named.
doesn't have to drink anymore. Whom? Okay. Can we refer to them as carrier's name? We shall not speak.
Oh, we're
All
still
right.
trying. Hey, we're getting
Poor,
it right. We're
poor
getting
Frank. Every time we say the word State Farm, he's having to drink, and it's really killing him. So we should really stop saying the word State Farm as much as possible.
Yeah, State
because
Farm is probably a name we shouldn't keep bringing up.
we should not say State Farm anymore.
I won't
No.
say State Farm anymore.
This is the last time I'm saying State Farm for Frank's sake, because every time I say State Farm, he drinks.
Poor Frank's gonna have alcohol poisoning by the end of this. He's gonna be in the hospital. We're gonna feel horrible.
He might be used to it. Now, P.O. would be acting as a lawyer, probably. All right, give me some good questions, guys. What do we got left? Oh, we're pretty much at the end of everything anyway. So let's see here. Ooh, Edward Faco. I haven't seen you on the show in a while, bud. Nice to see you. Tony DiUlio. I think you have to say it with an accent to really make it come out.
Oh yeah, DiUlio.
DiUlio.
Say it with a real deep voice.
Really
Good
deep.
day.
DiUlio.
Edward, hey, so like I said, it's actually an associate in my office in Philadelphia, Mike Casper. If you go to my website, you can find Mike's profile. He's from Chicago originally and is still licensed there.
There you go. That's not the best question to end on, though. Security takes a long time to extend coverage, and during that time, they exhaust ALE. Will you argue that there is no ALE till such time as they extend coverage? I.e., they will be pissing away the carrier's money on ALE to the end of the coverage extended. End to the date of coverage extended. So,
all right. So I think what they're getting at is, let's say the client has to move out of a property.
they have to.
Carrier hasn't extended coverage for it.
It's unlivable.
By the time that the carrier says, yes, there is ALE, they've now exceeded the limits. Let's say they've got a $30,000 limit on ALE. They blew through that in 4 months, and now all of a sudden they're out of it.
That is what he's saying. He's saying exhaust ALE.
Right.
I missed the word exhaust. All right.
Now,
So would you argue that because all of that time had passed and they wouldn't have incurred so much of that cost had they not delayed the claim, then is that additional cost that shouldn't be outside of the ALE limits?
I would argue it, but I'd probably lose it. So the reality is those limits are very hard to overcome. So
What if you ended up with a bad faith
verdict
as a result of delay?
Yes. So if that would absolutely get into the pot of measures of damages. There's no question. If I get to the bad faith verdict, that money's in there, no questions.
Okay.
But that's what you're going to have to get. And as you should know, bad faith standard of law, it's a higher standard of evidence to prove bad faith, clear and convincing evidence. It's going to be a difficult case, no matter what. Look, we fight it, we win it, but not every case is bad faith. Almost every time I get a call from an adjuster, it's
always,
oh my gosh, I've got a great bad faith case for you. I'm like, oh great, so you're the 6th one today. That's so weird. We did it. I did my own study, and it's rare that I actually get the time to do it. But we'd done a study on bad faith verdicts. It was 0.002% of verdicts actually had a bad faith award in them.
Are you serious?
It's extremely low. And
I've had probably 5 or 6 strong bad faith cases that I've handed off to an attorney over the years. And of those 5 or 6, not a single one made it to trial. So it didn't matter in the state that I was in.
Right. And that's always the caveat for my study, is that's only cases that went to trial. So they could be being settled at a higher rate. But what I'm trying to get at is they're always an uphill battle. There's always a difficult side to that.
It would be hard because a lot of times you're having to prove intent.
Yep.
And that's very difficult to prove.
You have to prove knowledge. I mean, proving knowledge of somebody is very difficult, right? You have to prove they knew they were being unreasonable.
Do you have to prove that the individual knew or that the carrier as a whole knew?
Carrier as a whole.
Huh. Is that harder than an individual?
Yes.
But isn't the carrier made up of many individuals?
Yeah.
And many individuals would likely, there's going to be someone in there that has a much higher knowledge than other people, right?
So the nice part is that as long as you're dealing with representatives of the carrier, you've got a pretty good round. They're an agent of, I won't say them again, Allstate. Let's say they're an agent of, they're an adjuster of Allstate. They're a representative of Allstate. What they know, Allstate knows. You're good. The problem, and what I'm sure everybody is seeing, they're hiring a lot more IAs, and when they get the independents involved, now they're creating insulation, so that they're now saying, "Oh, yeah, IA might have known this, but we didn't know it." Prove
right. And we relied on
this
their testimony and their expert documentation because they relied on that third party. The insulation is there.
That's why they're doing it.
So you have to tie in some kind of an intent to deceive with that IA firm or that third party representative engineer to say that there was something there. That'd be very difficult.
The easiest way to do it? That rebuttal letter. Don't send it just to the IA. Send it to whoever the inside person that carrier is as well. Now we've got direct evidence to the inside carrier.
I always like to try to get the adjuster to ask the third party person a specific question. And a lot of times they will not ask that question to that individual unless I post that person's email address on there as well. Of course, they might still not respond, but at least there's documentation that we attempted to get further clarification.
Number one thing missing in a file is documentation.
That's sad.
I know.
You guys need school.
Yep.
I
absolutely need school.
Oh, we got a lot of comments today. You are driving a lot of comments, my friend. Maybe a stupid question. Hey, they're all stupid.
I was just about to say, there's no stupid questions. There's just stupid people.
So I like yours too. But when a homeowner's looking at for the cost of lawyer, maybe a stupid question to ask. What are homeowners looking at for the cost of lawyer in most of the situations?
So most of us that do this work do it on a contingency fee. My firm, for example, will have different fees based off of the amount of the loss. Smaller the claim, higher the fee. It's just the nature of the beast. It's unfortunate, but it's true. Mm-hmm. So you can have a scaled system. So, first X amount is at one fee, then the next X amount is at a lower fee, and it keeps getting lower the higher the claim gets. That's what a lot of them will do. One of the nice things, just to plug myself a little bit, we front the costs for the insureds. So filing fees, service, experts, all of it comes out of our pocket, and we don't ask for it back if we're not successful. So that there's zero risk to policyholders in the event that they're unsuccessful. It's not very often. We don't lose really much.
There are a lot of attorneys that do it that way, but in order to do that and be successful, you have to be good.
That's exactly right.
So if there are attorneys out there that are doing that, that's usually a good sign.
Yep.
What about these third-party inspectors that are not adjusters or contractors that are able to deny damage based on their opinions, based on current influence? Now, all right. So they're not the ones denying it technically, right?
Correct.
They're just giving their opinion to the carrier who is making that decision.
Correct.
But here's my best argument against it. You've got a ladder assist. Let's call it a ladder assist of an engineer, just for the ease of use. You got a ladder assist. It's not trained, doesn't have any credentials. He goes out there with a camera. And he takes photos, and he sends those photos in. What is he taking photos of? Is he going to take photos of the entire roof? Every shingle that's on the roof? Or is he going to take photos of only the stuff that he thinks are damaged?
Yep.
So what does the carrier get to inspect? So if the carrier is the one making the decision on coverage, and they're the ones that have fully investigated, did they really? If they only got photos of 10 different areas on the roof instead of the entire thing, who really made the coverage determination? Because it really depends on what documentation is sent in.
I agree completely with all of that. The truth of the matter is, and what the courts have come down to say is, look, carriers can hire whoever they want to rely on. They might be wrong. They might be, even, you might get lucky and get the bad faith, but it's really hard when you have a third-party expert in most states to prove a bad faith claim, because the courts come back and say, well, look, it was at least reasonable for the carrier because they relied on some third party.
Sure.
And what the courts end up saying is the carriers have every right to do that. They can hire, any Joe Schmo because there's no licensing requirements. There's no requirement on the carrier side that whoever's doing that job have any kind of credential. It's not the same as with the client and the public adjusters. You guys have testing, CE credits, all of this stuff. You could, be a high school senior at 18 years old, know nothing about this industry, and go work for State Farm or Allstate or Farmers as an adjuster.
And that provides a reasonable basis for denial, though?
If you're relying on a third party, the courts have
It
come
doesn't
down
matter
and said
what
yes.
the third party is. It
It's-
could be a stay-at-home mom.
I couldn't agree more, but
Yeah.
the truth is the courts come back and say it's at least reasonable for them to trust that whatever company they've
But it's
relied
not
on.
reasonable for them to trust someone that doesn't have credentials to back it up. They need to at least establish. I think that there should be something added to the unfair claim settlement practices. And it's kind of in there. You know, an insurer-owned contractor has to have something in place to verify the workmanship of that contract. That's in the unfair claim settlement practices. What if the third-party inspector is considered one of the contractors owned by the carrier? Then they have to verify the workmanship or the competency of that third party. It's in the unfair claim settlement practices. So if they're not verifying competency, then can they establish that there is a reasonable basis for denial?
Look, I agree. It should be in there, but
I think I just gave them something new.
but the truth is the courts just they're not willing to go that far, because what level of investigation could the carrier are you wanting the carrier to do? If they get Hilaterus, they don't know if they're going to get John Smith or Jane Doe or Paul Bunyan to do the claim. They're trusting the company.
I don't know.
That's
If I
how the
got
courts
Paul
say it.
Bunyan, I'd be pretty impressed.
Sure.
Yeah. All right, guys, we're going to have to cut this off. I know there's a lot of questions that are still out there. I really appreciate you putting your questions in the comments, but this bar is shutting down.
Yeah.
And we have to get out because they're
Yeah,
giving us the stank eye.
We're the last ones here.
We are. But, you know, Tony's paying for all of it, so it's fine.
I'm happy to do it.
I have no idea who's on next week because, as you all know, I completely deleted my entire calendar. If you are scheduled to be on next week, please reach out to me because I fucked up.
Or just tell them how much you want me back.
Yeah.
Right? That's
Yeah.
fine.
I'm just, that'd be great. If you could reach out to me, I'd really appreciate that. I am retarded and did that. So, but either way, I'm really liking this 8 o'clock time slot. Nobody has commented whatsoever on whether or not this 8 p.m. slot is the better slot or if we should go back to 4 p.m. or not. And I haven't seen a major audience change yet. So I really don't know if this is right. But to be honest, it's a lot easier on me. So right now, I'm feeling good about 8 p.m. Let me know if you guys are okay with that or not. For those of you that still have questions in the comments, I know Tony's going to go back and try to answer as many as he can. I'm going to post his comment or his contact information on the YouTube video that is going to be created after this live ends. And I'll make sure to tag him on things so that he can share a bunch of stuff. But if you would go back and just answer any questions that are still there in your spare time, that'd be great. Give him a few days to do so because you are at a convention.
Yeah.
Yeah, I think that's about it. Any final statements?
No, just thank you so much, Matt. Really appreciate you having me.
Thank you. This is where we're supposed to shake hands and act like we're walking away from each other. Like we're not getting into a car together.
Right.
It was great to have you.
Yeah, right. Pleasure.
All right.
Here we go.